The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, Council, and welcome to you as well as those watching on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the Clerk of the Kansas Appellate Courts, to please call the afternoon docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, May 27th, 2021 consists of two cases. First case is appeal number 122237, State of Kansas versus David Montgomery, Johnson County, briefs both sides. The second case immediately following will be appeal number 123589 in the matter of Kevin W. Kenney, original action and attorney discipline. Your Honor, the appellant in State versus Montgomery has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, James Latta of the Appellate Defender's Office, representing David Montgomery, ready for argument.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellant in this case, although not the petitioner, the State of Kansas, present and ready for argument.
Thank you, Counsel. Mr. Latta, you may begin.
Thank you, Your Honor. The facts in this case aren't too important to the narrow legal issue on appeal, but I'll cover how we got here real quickly. David Montgomery pled guilty to aggravated domestic battery. He had a B criminal history score, and as part of that criminal history score, he had a prior person burglary and robbery. He moved for disposition or departure, and the district court granted that, stating that he had no prior domestic violence convictions was the reasoning below, and the state appealed. And on appeal to the Court of Appeals, the Court of Appeals reversed, finding that sole reason to be legally insufficient. And then we are now here on the petition. And to begin with, as me and the state have gone back and forth on framing of the issue, I'll start briefly there. The way I see the issue is whether we can allow, as a matter of law, dissimilarity between past and present crimes to allow for a departure in any case. And the one thing I'll point out is we've been focusing on the district court stating there were no other domestic violence charges within the criminal history. The district court went on to also say that while he had some felonies and burglaries and other unrelated offenses, so when you really take it all in context, I think the correct framing of the issue is whether dissimilarity can ever, as a matter of law, lead to a dispositional departure. And then turning to the Court of Appeals opinion, it's our position that the Court of Appeals ruled solely on whether the dissimilarity of prior convictions can ever, as a matter of law, lead to a departure. And my reading of the Court of Appeals opinion is they did not get to, so as this court knows, we're now operating under Morley. And my reading of the Court of Appeals opinion is they only ruled on step one in Morley, which, as we now know after some fine tuning, means that whether or not the dissimilarity of prior convictions can ever, as a matter of law, lead to a departure. And where the Court of Appeals was mistaken was they were using the facts of this case to get to its ruling on whether that departure factor can ever, as a matter of law, lead to a departure. And as we know from the way I read Morley, at step one, the only thing, we do not look to the facts of this case to determine whether a departure factor can ever be a mitigating circumstance. We only look to see if that factor is consistent, if it's not a enumerated factor, consistent with the Kansas sentencing guidelines.
Counsel, that leads into my first question, which is I've kind of been stuck right out of the gate in this case by the words similarity and dissimilarity. And what hangs me up is just how subjective that concept is. How would we even be able to make a legal rule that defined what counts as similar and dissimilar. I mean, this court has a whole lengthy jurisprudence on trying to compare in-state versus out-of-state offenses and when they're comparable and not, and that's hard enough to figure out. But this just seems so subjective, I guess, as to whether a prior offense is similar or not.
Sure. I understand it. And my answer to that would be, at the first step, this court hold that dissimilarity, just in general, can always, as a matter of law, be a mitigating circumstance. But to get to your concerns, Your Honor, when we get down to step 3, when we start looking at the facts of the case and the substantial and compelling reasons, that's where we can step in and say, well, these facts don't force us. This isn't dissimilar enough. And the facts of this case don't force us to leave the status quo.
Is dissimilarity even a real thing? Aren't we just basically skipping the first step entirely? Because every prior crime is dissimilar in some fashion. And so that's what I'm struggling with is it even a factor at all? If it's something that's always present, the prior offenses are always dissimilar.
Sure. I think it should still be a factor for the, I don't know that they would always be dissimilar. I think we're just looking to the actual crime. So if you have a battery conviction and you have 2 prior batteries, I don't know how you could say those were dissimilar. And then from there, we can always go to the third step to quell many of your fears about these leading to a departure in any case. So I certainly think we can have dissimilarity when looking just at the, not looking at the underlying facts of any prior convictions.
If I can follow up on that to be sure I understand what you are arguing there. If it's the same crime, is that what you're saying, is just that it meets the same elements of the same crime, it's a similar crime without looking at facts at all?
That's how I would do it. I mean, if we just are talking about similarity and dissimilarity, I think we just look to the prior convictions.
Right. And I'm just trying to decide what is similar. Is it just elements are the same or similar versus something like this where we have domestic violence and burglary, which are very different on their face, elements are very different. Which puts them in the similarity, dissimilarity silos. How do you get there at this first step?
For the step 1 under Morley, I think what my client and I would have hold is that dissimilarity can always be a mitigating circumstance. Whatever that, just in general, based on it's consistent with the Kansas Sentencing Guidelines Act.
I understood that, but I'm trying to decide, how do we define similarity and dissimilarity to apply that rule of law?
I would just define it as the crime on its face. If it's a burglary and you say a burglary is dissimilar from a different burglary, then I don't think that'd be correct. I mean, I guess we could go to the underlying elements. I don't see a reason to. I think we could just stop on the face. And just like in this case, when they just say there's no prior domestic violence convictions, I mean, there were no prior domestic violence convictions.
And just to launch off what Justice Luker is saying, so would you also be comfortable with saying that similarity is if it was violent or if it was a person versus a non-person? I mean, where do we draw the line?
Are we saying if it's similar, then you could grant an upward departure? Is that?
No, we're talking about mitigation, right?
Right.
Mitigating circumstances. So the first step is, can a non-statutory factor be a mitigating factor? We're talking about similarity. So in other words, could the judge have said, they're similar or not similar because they're both involve violence, or they were both person felonies? I think that's what, I mean, I don't want to speak for her, but Justice Luker is saying, do we do the elements or do we go broader? Where do we draw the line?
I understand now. Thank you, Judge. I would say that we we allow the district courts to draw, because at step one, we just look to the consistency with the guidelines. And so what I would have this court hold is that dissimilarity can be a departure factor in the right case. So we allow that to be a factor in the district court to define that in that case as they want. So if they say these are dissimilar, then we will accept that and we'll say that can be a mitigating circumstance in the right case. But that won't happen in every case, because we always have step three, which is pretty demanding on the defendant, where we'll step in and go, well, we don't think these are dissimilar enough. However, this could be where the court wants to say, well, look at the elements. These are actually similar. They have similar requirements. And so this can't compel the court to leave the status quo. I mean, that's where we would ask the court to put that analysis in step three, based on Morley. And if there's no other questions, we just ask that this court reverse the Court of Appeals and affirm the district court and find that dissimilarity of past and present crimes can be a mitigating circumstance in the right case, under step one in Morley.
Does it have to go back if we find that the Court of Appeals erred? Does it have to go back to determine whether or not, or I guess for step two and step three for the Court of Appeals to decide that?
No, we would ask that, because our position is the state did not argue whether it was supported by substantial evidence or whether the district court erred by acting unreasonably. And because an abuse of discretion standard always, the burden is always on the person raising the argument, we would ask that those two steps, this court not get there, and just under step one, rule that it's a legally sufficient factor, and therefore reverse the Court of Appeals and affirm the district court.
Any other questions? Okay, thank you, Mr. Latta. Mr. Gonteski?
Madam Chief Justice, and may it please the court. The district court acted both unreasonably in this case and as a matter of law, and the Court of Appeals got it right when they recognized as much. And that's why the state is asking that you affirm the Court of Appeals ruling in this case. To first address, there's 3 points I'd like to address today. I'd first like to touch on Morley and its application in this case. Next, beyond that, I'd like to discuss very briefly the framing of the issue and why the state frames it as it does. And then third, I'd like to talk about the core of the issue, which is why this is never a substantial or compelling reason to depart as a matter of law in this case or in any other. The Morley case, I believe, did provide some clarity to the standard of review under which this court and the Court of Appeals will review departure issues such as this one. But I believe at its core, Morley provided some much needed clarification to the law, but I don't believe as though it provided any substantive change from the law that the Court of Appeals applied in this case. And while Morley captions it all as a abuse of discretion standard that applies to all of the steps, when you look at each step, the very first step on whether or not a certain factor could ever, as a matter of law, be a departure factor, if you review that under an abuse of discretion standard, which Morley encourages courts to do, then the only question there is whether or not it's an error as a matter of law. And errors as a matter of law are reviewed de novo or unlimited. And that's what the Court of Appeals did here. And so even under the Morley standard, I believe what I'm getting at here is that I don't believe as though the Court of Appeals diverged from Morley, nor do I believe as though Morley significantly changed the landscape in a way that this needs to be recalibrated. Here, I believe as though the Court of Appeals got it correct in that sense, and that they applied the correct standard of review. Secondly, in framing the issue, the state has repeatedly framed the issue by using the words of the district court. And the words of the district court in this case, I'll read the entire paragraph where they describe the departure in this case. Quote, "The determining factor is multiple things in this case. Although the defendant is a criminal history score of B, those charges, there were no other domestic violence charges within the criminal history. I understand there were some felonies. There were burglaries, as pointed out by the prosecutor. There were a number of other things that were related to license and driving on a suspended as well that make him a B. That's the entirety of the paragraph from the transcript on why the district court departed. And the state has maintained that the proper framing of this issue is whether or not a lack of domestic violence priors can ever, as a matter of law, constitute substantial and compelling reasons to depart, and also whether or not in this case it was substantial and compelling as a basis to depart. The state's wording in both its brief.
Let me ask you something.
Yes.
Your initial posture on this case, or I shouldn't say yours, but the state's initial posture was this was a plea, and you had a plea agreement to probation. And so, and then you articulated, well, there was a breach of that agreement by some no contact order violations. But what was the initial reason for you agreeing for the departure? And what's the problem here with the court kind of relying on your position in the first place to grant a departure? It's that they weren't articulated, or that there's no basis? Because you agreed that there should be a departure initially.
We did. And that's getting into, to be frank, that's getting into some facts that went on that are not part of the appellate record, but the facts that went on as the case progressed from the plea posture on one hand, and correspondence and interactions that the state had with discussing the plea with the victim in this case, and then interactions that the defendant had with the victim after the plea. There were more violent interactions between the two that formed the basis of the state's motion to revoke the defendant's bond and bring him back before the court.
But how did that post-plea contact change the your initial joint request for departure? Because obviously you thought there was a basis for departure initially.
The state did, Your Honor, and I believe that had been informed in part by input from the victim in the case and the state's understanding of the nature of their relationship and what it would look like going forward. And when all of that essentially blew up, when the pair had more violent contact and police interaction, that's where the state's support of a downward departure fell apart.
Okay,
and that's where the state.
So part of your consideration was kind of the ongoing nature of the relationship was not violent. Therefore, probation, and there would be some grounds for departure based upon that.
Correct.
Okay.
And to be clear, the defendant's motion for a departure was not on the basis of him lacking prior domestic violence convictions. That's not the basis under which he even moved for a departure. That is the basis that the district court chose. The district court did not elect to depart on the basis of the request made by the defendant, which was related to the age of his priors and things like that. The age of his priors and the fact that they were several years before was in large part because he was in prison for his prior offenses. He had just been off of post-release for 2 days when he picked up this case. And so it was their continued violent involvement after the plea that informed the state's decision to request from the district court that the state no longer be held to the plea agreement. So I hope that answers your question, Justice Rosen.
But while the post-plea conduct informed the prosecution's decision about whether to stay with probation, was the court free to look at those same facts to make a decision, or was it required to look at what was in effect the original basis that the state agreed to probation? You see what I'm getting at?
I do. I believe as though once the district court released the state from the plea, that the district court was no longer bound in any way to hold the state to its recommendation that a departure be granted on other bases than what the district court ultimately found. And the district court, given that it imposed the downward departure against the state's request, it appears as though the post-plea conduct essentially had no impact on the district court, because the district court, even in the face of continued violent contact, the district court nevertheless imposed this downward departure against the state's request. So on the question of whether or not that post-plea conduct should inform the district court's departure decision, it's a valid question, but I believe it's one for another day, because it appears as though it didn't inform the district court's decision at all here, because the district court nevertheless departed downward.
Counsel, what you read the ruling just a moment ago, what the reference to multiple things being the determining factor, is there anything in the record that informs us what multiple things are being referenced beyond the priors?
Not that I can find in the record, Justice Wall, and we've gone through it with a fine-tooth comb. I know myself, and I know Mr. Latta has. But that paragraph is the entirety of the district court's ruling on the departure. And although it does start out by saying multiple things, it then only references his lack of domestic violence prior convictions. And what I'd like to get to, I've already explored the framing of the issue, the second area that I wanted to touch on. And I'd also like to briefly note that Mr. Montgomery raises two cases from the Court of Appeals to assert the point that our appellate courts in Kansas have already previously determined that dissimilarity can be a substantial and compelling reason to depart as a matter of law, the Heath case and the Richardson case. But there are a couple of primary distinctions between our case here and Heath and Richardson. And that is that in Heath and Richardson, the dissimilarity was one of multiple bases upon which the court found to depart, and the other factor being the age of the prior convictions. And here, and also in Heath and Richardson, the district courts had expounded upon the fact that the current present offenses were not violent ones. And so there was not a public safety risk there. But here we're confronted with a different scenario under which the district court departed only on the basis of the lack of domestic violence priors and did not ever reference the age of any of those priors. But third, regardless of framing, and the state has maintained, and the state included all of its authority in the petition for review in its supplemental brief with this court, the state has maintained all along, both as a matter of law, in any case, this is an invalid basis upon which to depart. And also in this case, this was not a substantial and compelling reason to depart. And I'd like to roll those together to try to answer a couple of the questions that were raised earlier, a couple of the points that were made. And I agree, Justice Stiegel, this is a particularly subjective basis upon which to ever grant a departure. And when you start exploring the different permutations, you start realizing that endowing such a subjective factor with blessing it as a potential departure criteria essentially unravels the guidelines. And in 1990,
let me jump in and ask the same question, or what seems to me to be the same question, but a slightly different way. It strikes me that the similarity or dissimilarity of prior convictions is something that is already baked into the sentencing guidelines.
I agree. It absolutely is. And that's why we have person versus non-person crimes. And that's why we have different varying degrees of severity level. Those are baked into our sentencing structure. And when you start drawing upon something like this as dissimilarity, one point I raised in the supplemental brief, and I still have yet to really be confronted with how it gets resolved, is in particular, what is compelling about dissimilarity? What is it about a defendant having a diverse range of criminal conduct? What is it about that diverse range that justifies leniency? And the counter to that would be, are we now in a position to say the sentencing guidelines are going to treat more harshly defendants who stay in their chosen lane of criminal travel when somebody keeps committing domestic violence acts? Is that someone who deserves more punishment than somebody who beats up strangers and is violent against individuals who he has no history with? I fail to understand what is compelling, what forces a district court to stray from the status quo by virtue of a defendant choosing to commit different types of crimes. So even if we caption it as the broad dissimilarity that Mr. Montgomery seeks to frame it as, there's nothing compelling about a defendant who commits crime in a number of different ways. But furthermore, to Justice Stiegel's point, this is particularly subjective, and that gets to the other prong of a departure. I talk about why it's not compelling, but it's not substantial either. Substantial, this court has held time and again, is something that is real, not ephemeral, something that has substance and that is relevant to the case. There's nothing particularly relevant to the case about him committing different types of violence against different groups of individuals. Rather than strangers upon which he did not have a domestic relationship, now he's strangling his girlfriend unconscious. There's nothing substantial about the difference between those crimes that isn't already accounted for in the guidelines. And one of Mr. Lotta's responses earlier was when the question was raised about, well, how would a district court put into place, or what would be the guardrails of that subjective criteria of dissimilarity? And one of the statements he made was, we should allow the district court to define that. The problem with that is the Kansas sentencing guidelines have been put into place for the precise reason of creating uniformity and creating sentences that across the state would carry some more uniformity than what we had before the guidelines. Before the guidelines, when we had broad brush sentences, they became disparate across the state and in different courtrooms for that very reason, because they were too subjective. And so if the guidelines are going to carry any meaning, they need those guideposts and those guardrails that come with defining the factors under which the district court can depart.
But counsel, if we, here's what's bugging me. So respond to it. If we're at step 3 of the Morley framework, and we're just trying to consider, decide whether, there's a reasonable basis to depart, how do you say it's unreasonable when the state prosecutor agreed to departure? It's the same set of facts. I mean, if the court's saying dissimilarity, and you conceded that similarity and dissimilarity are baked into the cake, it's in the sentencing guidelines. So from my perspective, that gets us past step 1. Step 2, is there dissimilarity? Well, factually, we can look at the crimes and see whether something's different or not. So now we're playing at step 3 and analyzing it. And I've got the state prosecutor who agreed to a departure. So how can we say it's unreasonable for this judge to go with departure?
I think part of that, Justice Files, would be that agreement of the parties as to a sentence to recommend the district court is often part of the calculus that goes into a plea agreement. When the parties decide what sentence they're going to recommend to the court, the fact that they were able to come to an agreement on the especially upon the understanding that bond conditions would be followed and that we would arrive at sentencing in the same position we're at the time the plea is negotiated, then that agreement of the parties carries significant weight. And in a posture in which the parties agree to a departure, then neither party is in a position to appeal one when it's granted. And so I don't think it is uncommon across the state for parties to agree to depart to a given box and not necessarily fully flesh out what the legal basis of that departure would be until and unless the district court calls upon the parties to do so. And in those scenarios, often what is hoisted is the agreement of the parties, or input from the victim, or other factors that here were no longer present at the time the state arrived for sentencing after further violations of bond had been established. So I hope that can resolve the question to the extent that Justice Biles is drawing back upon the state's position before the bond violations had been committed. I believe is that.
Excuse me. So you're saying that the agreement of the parties can be used as a factor by the district court as partial justification for departure?
Yes.
But in this case, the court did not cite that.
Correct.
And the agreement perhaps was not in play anymore, right?
That's absolutely correct, Justice Wilson. There was agreement of the parties to recommend that probationary sentence before the bond violations had been established. And the district court did allow the state to no longer support the plea agreement. That issue was never appealed by Mr. Montgomery. The district court allowed the state to step away from the plea agreement and recommend a different sentence as a result of those bond violations. And so that agreement of the parties was no longer a factor that was present, and it is not one that the district court used. I would encourage this court to be looking at the issue that has been raised about whether or not this is substantial and compelling in this case or in any other, without particular reference to the state's position before the bond violations were established, because what we're looking at is the larger legal question of whether or not this can ever be a substantial and compelling reason to depart, and whether or not it was substantial and compelling in this case. And the state asserts it was not in either case, in any case or in this one. And I would ask that this court affirm the Court of Appeals ruling as much and remand the case back to the district court for resentencing.
I want to see if I'm framing your argument correctly in this context. As I understand it, a defendant could have a fairly substantial criminal history that would result in but it could be no violence, really maybe not even a personal felony of any sort. And so in a way in which many people, maybe all people, would say it was out of character for this person to react in a violent way or to take a violent action. Under your argument, that still would not be a basis for departure, because the fact that this violence was the first and only time in, say, somebody maybe quite old or fairly old had ever done anything like that, that lack of similarity to past criminal history wouldn't be a factor the court could consider.
I don't believe it would be a factor to justify departure, Chief Justice Lukert. And the reason why is because if a defendant has a lengthy criminal history that is all nonviolent, they're going to max themselves out on the Kansas Sentencing Guidelines grid as an E. They're never going to get up to D or C or B or A. And so as a result of their lack of nonviolent prior convictions, they're already going to get a lesser sentence than somebody who has violent prior convictions. The person who has prior convictions of violence against persons is going to be scored as a C or a B or an A, and they're going to already carry a higher sentence. But the individual that you posit appearing before the district court with no prior crimes of violence, but a lengthy prior history of property crimes or drug crimes, is going to be lower on the sentencing guidelines grid. And so that factor, as Justice Stiegel put it earlier, is a factor that's already baked into the sentencing guidelines. A lack of violence is already there because you can no longer get above an E if your prior convictions lack violence.
Counsel?
Yes.
What if you change just Chief Lukert's example just slightly, and you have all those nonviolent convictions, except for one or two that happened when he was 15 or 16 years old, and now he's 57, and it's nonviolent? Then how would you analyze that?
I think then you would analyze it similarly to the Heath or Richardson court, in which they analyzed a sort of full picture of the defendant's criminal history, and they rolled together the different nature of the crime with the age of the crime. So Justice Wilson, to your point of somebody in their 50s and they only have 1 or 2 prior person convictions that were in their teens or 20s, 20 or 30 or 40 years ago, that scenario is one in which the substantial and compelling reason to depart would at least in part be the age of those prior convictions, as the Heath Court recognized and the Richardson Court followed up with. So combining that with other factors, perhaps you get sort of a totality of the criminal history picture that would inform a district court in a manner in which they could depart. But when you're looking exclusively only at the dissimilarity or similarity, that's where I fail to see a legal basis upon which a court could depart. So your scenario could already be resolved via a departure whereby the district court considers the age of those priors. The state is not contesting the fact that age of prior convictions can be a substantial and compelling reason to depart, but that's not one that's present in this case today.
Other questions?
Seeing I'm out of time, without absent any other questions, I'd simply ask this court to affirm the Court of Appeals ruling, but I'm happy to answer any more questions that this court may have.
I don't see any more. Thank you, Mr. Gonteski.
Thank
Mr.
you.
Latta, you reserve 3 minutes.
Thank you, Chief Justice. I would like to respond to at least one thing. Constrained subjectivity is not a bad thing. These are human beings that are being sentenced here. We can't just plug them into a formula and think we're going to get a just sentence in every case. And so going back to Justice Stegall, I'd respectfully disagree that these guidelines take into account everything. Not all person felonies are created equal. I mean, some failure to registers are person felonies. What if someone has 2 person felonies for criminal threat as opposed to someone else who has a manslaughter? I think that's why I believe that dissimilarity should be a mitigating circumstance that a district court can use and define as they see fit in that case. And then we have step 3, where the appellate courts can look to see if it truly was compelling in that case and substantial. So I am in no way saying that every time a defendant has a wide array of criminal history, they should get a departure, but it should be something that could be looked at, because the guidelines certainly don't take into account the specific person felonies or even non-person felonies. And with that, Your Honors, unless there's any questions, we would just ask that you reverse the Court of Appeals and affirm the district court, please.
Thank you. Thank you to both counsel for your arguments today. The court will take this appeal under advisement. We will now turn to the next case on the afternoon docket. Mr. Shima, would you please call the next case?
I think we've lost.
Justice Standridge is recused.
Oh, my bad.
I was going to announce that in just a minute.
Sorry. Your Honor, the second case for the docket is appeal number 123589 in the matter of Kevin W. Kenney, original action and attorney discipline. The disciplinary administrator has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Yes, and as our exchange highlighted, Justice Standridge is recused in this case. We do not have a substitute sitting for her, so we will resolve it with the 6 remaining justices. With that, I would ask counsel to please state appearances.
Thank you, and may it please the court, Crystal Vokins appears on behalf of the Disciplinary Administrator's Office petitioner.
Madam Chief Justice, Your Honors, may it please the court. The respondent appears in person by John Ambrosio. We are ready to proceed.
Ms. Voykins, you may begin.
Thank you. And I believe Mr. Shima has already indicated, but I request that I be allowed to reserve 3 minutes for rebuttal.
So noted.
This is an original proceeding in discipline against the respondent Kevin Kenney, who was admitted to the practice of law in Kansas in 1996. This action involves 2 underlying adoption matters out of the Wyandotte County District Court. The first is matter of adoption of CL. The second is matter of adoption of baby boy F. In both adoption proceedings, the respondent filed petitions for adoption with the district court, alleging that the biological father's parental rights should be terminated pursuant to KSA 59-2136H1. These pleadings included allegations that were without merit, were made without proper investigation into the facts, and contained material misrepresentations of the facts. The matter of adoption of CL case came before this court on petition for review, and this court rendered a decision reversing the adoption and termination of parental rights. In that case, the respondent filed a petition alleging the following factors supporting termination of the biological father's parental rights: that the father, after having knowledge of the pregnancy, failed without reasonable cause to provide support for the mother during the 6 months prior to birth, that the father abandoned the mother after having knowledge of the pregnancy, that he made no reasonable efforts to support or communicate with the child after having knowledge of the birth of the child, and that the father abandoned or neglected the child after having knowledge of the child's birth. The hearing panel found these allegations were made without proper factual investigation and were substantively false when filed, because in that case, the biological father had only learned of the mother's pregnancy and the birth of CL 4 days before the respondent filed the adoption petition. Similarly, in the matter of adoption of baby boy F, the respondent filed a petition alleging, among other things, that the father there made no reasonable efforts to support or communicate with the child after having knowledge of the child's birth, and that he had abandoned the child after having knowledge of the child's birth. The hearing panel found that at the time respondent drafted and filed this petition, the biological father in that case did not even know that baby boy F had been born. The father learned of the child's birth when he was served with the adoption petition a few days later. The respondent not only signed and filed these 2 adoption petitions as an officer of the court, but he also had his clients in both cases verify these petitions under oath. Our office and the respondent entered into a joint stipulation that the respondent's conduct in these 2 adoption matters violated the Kansas rules of professional conduct. The hearing panel found the following rules violated: 3.3A1, candor to the tribunal; 3.1, meritorious claims and contentions; 8.4C, misconduct involving dishonesty, fraud, deceit, or misrepresentation; and 8.4D, misconduct that is prejudicial to the administration of justice. Our office recommended 18 months suspension as a sanction for this misconduct. The respondent recommended public censure, and the hearing panel ultimately recommended a 6 month suspension. Our office did not file a statement of exceptions to the hearing panel's report. However, as allowed by Supreme Court Rule 228F, our office does continue to stand by our recommendation of an 18-month suspension. The hearing panel found that the respondent's duty violated was his duty to his clients, to the legal profession, and to the legal system. They found that his mental state was that he acted negligently and knowingly, that his general adoption practice, as admitted by the respondent, was negligent, and that in these 2 particular adoption cases, the respondent acted knowing that the claims he made were meritless and substantively false.
Counsel, can I stop you there? It does seem to me that based upon the responses by Mr. Kenney to your complaint and the hearing panel findings, that this was a pattern in practice. I mean, you've tagged him on 2, but this was a routine practice to make these allegations that were taken right out of the statute without factual investigation, and then having clients verify the accuracy without a factual investigation. Is that the way you understand the facts?
Yes, Justice Biles, and I believe the respondent even testified during the hearing that it was his practice to include many of the statutory factors under this statute for termination. We don't have any direct evidence that those factors would have been false or, meritless, as the facts in the 2 adoption cases that we did hear about was established. However, he did admit that this was his general practice. The third consideration that the hearing panel made was the actual injury in this case. And the hearing panel stated regarding this that the injury caused by the respondent cannot be remedied and will be long lasting. And I'll talk about this a little bit further soon. The panel applied ABA model standards for lawyer sanctions 6.12 and 7.2 in finding that suspension is an appropriate sanction here. The mitigating factors found by the hearing panel were that the respondent cooperated completely in the disciplinary investigation and proceedings. He self-reported his misconduct. His answer to our formal complaint admitted all the allegations, and he ultimately entered into a joint stipulation of admitting to his misconduct and to the facts. Other mitigating factors were that he has no prior discipline. He presented substantial evidence of good reputation and support of his colleagues, and that the respondent exhibited genuine remorse at the hearing. Aggravating factors found by the hearing panel, which goes to Justice Biles's question. First, the hearing panel found that there was a pattern of misconduct. Not only did this same thing happen in the 2 separate cases involved here, but the respondent indicated that it was his practice to include all statutory factors, or at least all potentially applicable, even if there was no factual basis, statutory factors out of what he called an abundance of caution. Other aggravating factors were substantial experience in the practice of law. The respondent was admitted to the Missouri bar in 1995 and to the practice of law in Kansas in 1996. And the respondent testified that he has practiced adoption law for over 20 years. Finally, vulnerability of the victim. CL and baby boy F were young children, and this was a traumatic situation for all of the people involved in this case, and all of them were vulnerable to the respondent's misconduct. Here, 2 biological fathers' rights were denied for far too long. The adoptions of the minor children were overturned 2 years into the minor children's lives. And these 2 little boys were transitioned out of the homes of the people that they believed to be their parents. Family bonds were interrupted and new relationships had to be established for the first time, years after they otherwise should have been. And the trauma involved for all parties is undeniable. For these reasons—
Counsel, let me jump in there and I guess my question is, the way you've framed the issues, given the frankly egregious misconduct and the very significant harm caused by that misconduct, why 18 months
and
as
why not
opposed
more?
to a longer period?
No, I think that's a very good question. Some of the factors our office took into consideration, well, I can't speak for the deputy who handled this hearing because I was not that person, but some of the considerations I take into account are the respondent's conduct during the disciplinary proceedings and his acceptance of responsibility. In addition to the fact that the respondent is a solo practitioner, and an 18-month suspension is not an inconsequential sanction under those circumstances. So our recommendation continues to be an 18-month suspension as discipline in this case, which we believe is appropriate, and I'll be happy to answer any other questions.
On the acceptance of responsibility, 2 things kind of jumped out at me. The first one was when the respondent, I guess, finally realized that maybe this wasn't a good thing to be doing. We have in the record that he modified his practice to include a line in there about that the respondent has done these factual things that can justify termination or is expected to. You remember that little phrase that's in there? And I can't figure out how his clients would be able to verify a petition that says that they would be, that the father or the parent would be expected to violate those things. I can't understand. So, you know, this is not a notice pleading kind of situation. And so it concerns me that the respondent doesn't get it. So you can, I guess, explain to me why you think he does. The other thing that bothers me is the notion of self-reporting, because, you know, I kept thinking about how I would have handled something like this. And I think I would have self-reported when Judge Malone did his concurring opinion in the Court of Appeals case. And the respondent didn't report until after the Kansas Supreme Court had issued its opinion. But I tell you what, I mean, that if you look at the video of that oral argument where we laid out these facts and he agreed to these facts, I think I would have self-reported about an hour after the oral argument. And so again, I wrestle with whether you've got substantial competent evidence to support, or I guess clear and convincing evidence to support the notion that he's accepted responsibility.
Well, when it comes to the reason for the request for discipline, I don't think we apply the clear and convincing standard there. That, I believe, is only applicable to whether or not the KRPC were violated. But your point is well taken. I agree that from an outside perspective, the violations were apparent much earlier than when the respondent self-reported. It appears to me from the record that the realization of the misconduct and the gravity of it and the need to change his pleading practices seemed to evolve over time through the disciplinary proceedings.
Doesn't that directly conflict the finding that Mr. Kenney lied to courts in pleadings? How can you knowingly make false statements to courts and then have sort of an evolving understanding after the fact that somehow that was not right?
Well, I think that he knew, it is clear to me that he knew that what he was saying to the district court in these pleadings was not true. I think that his understanding of the effect that has, and that after 20 years of practicing in this manner, that maybe that was not an acceptable thing to do. It could be that repercussions didn't come up until this far into his practice. And then once 2 adoptions have been overturned after 2 years, then maybe the gravity of...
Sorry, I got caught. That's what you're saying.
Well, I think it is clear. The misconduct is clear. He knew that what was going in these petitions was false. But yes, the realization was not apparent before his self-report, and then maybe didn't come to full fruition until into the disciplinary proceeding.
And when he self-reported, he self-reported only the CL case and not the other one, right?
That is correct. The deputy handling the self-report on the CL case came to find out about the baby boy F case and the similar misconduct. And I see I'm out of time, but if I can finish up my response to some of the questions that have been posed here. Yes. I have similar concerns. Our office has similar concerns about the respondent's understanding and acceptance of the fact that going forward, if he is to practice adoption again, then that the allegations he puts into pleadings need to have evidentiary support at the time the allegations are made, and not that evidence may come up into the future. Maybe that understanding can be exhibited today, but that would be a remaining concern of our office.
Let me ask you about that because I'm kind of confused. With an 18-month suspension, as you recommend, are you saying that you want a reinstatement hearing at the end of 18 months?
That was not requested by our office at the formal hearing. After reading the final hearing report, I could see why the court may find that that's warranted. But I also, perhaps at this hearing, there could be an exhibition of an understanding and acceptance of that fact. So I think that the court ultimately will make a determination on what is necessary there.
Anything else? Thank you, Ms. Vokins. Mr. Ambrosio?
May it please the court. Mr. Kenney will address you with your permission at the end of my stand on the floor, if that's appropriate. He'd like to answer some of the questions that have been posed. Let me start from the beginning here. The respondent accepts the panel's remarks, discussions of the facts, and the suggested discipline of 6 months. He understands why he has to be punished and why he must toe the mark from this point on. He agrees with the rules violations that have been outlined, and he agrees with everything the panel indicated during the course of their discussions with him when they asked him questions and also in their panel report. He understands that his mistakes and actions, and he's remorseful for them, and he has shown this every step of the way during this process. He self-reported, and it's not because he got caught. He self-reported after the decision came out, and apparently he did not realize the nature of his conduct up to that point. And I think it's so important that people get to understand, and even this court gets to understand, sometimes lawyers make mistakes. Good lawyers make mistakes. Moral lawyers make mistakes. And sometimes those of us don't think we make a mistake, and then we realize when we go through this process how devastating those mistakes are. I think
Counsel,
yes.
Are you suggesting that telling a knowing lie to a court is a mistake?
That would be absurd. Of course not.
Well, then I don't understand your argument, because
Well,
that's facts that are found, is that these were knowing falsehoods filed in court. And how can that, you just said it's not a mistake, and that's your whole argument.
He made a mistake. He made a mistake. He stood up to the plate, admitted his mistakes. And my remarks are not meant in any way to disabuse you of the fact that he is owning up to what he did wrong. He owned up to what he did wrong in his report to the court, in his second report on the second adoption. He owned up when he signed the stipulation. He could have made the disciplinary administrator's office, trotted everybody into that. He stood up to the plate and said he did something wrong. Now, admittedly, he was after the guidance of his lawyer in this case, and sometimes it takes the guidance from an advocate who's representing the person to do that. So you and I, Mr. Justice, disagree on what I just said. Going on, he understands that he hurt this child, although it's a baby and this baby will bounce back. He hurt those adopted parents who had to be utterly devastated, and he's remorseful for that, and he told the panel that. He understands what he did wrong. He is not alibying. He's not doing anything but falling on his sword before this court and before the panel. And I think that means that he's learned his lesson. He was less than terrific when he answered Justice Biles' questions during the Supreme Court argument. He was less than stellar when he answered retired Justice Johnson's questions. He should have fallen on his sword then and say, I see what you're saying. I understand what you're saying. It took him a while. And to hit him in the head a couple of times because it took him a while is not right for this court to do so. And he has changed this practice. He has changed this practice where now he dots every I and crosses every T. Now you're saying to yourself, then why didn't he know that before? He was practicing law for 20 years. People make mistakes. Good people make mistakes. History is replete with those type of things. He has straightened out his practice. Now, before he signs a pleading, before he allows his clients to sign a pleading, everything is investigated. Every little bit, or it doesn't go in the pleading. If he has to amend the pleading later on, he does it. This is a very small adoption bar. It's very small. They know each other. You can see from the letters how he's held in high esteem by everybody. Now he reaches out to those other adoption lawyers and asks questions every step of the way. He doesn't make mistakes that he would have made before, albeit that what he put in that pleading was wrong and dead wrong, and I guess some of us wouldn't have done that. It's great to look at it in hindsight. I wouldn't have done that. It's great to look at it in hindsight. I think I would have reported at a different time. Everybody operates differently. Everybody thinks through things differently. He has changed.
Counsel, let me push back just a little bit, because even if you accept, oh, I did something wrong here, his next reaction was to say, I've changed my pleadings. Well, first of all, he tried to justify it as, well, this is just notice pleading. And of course, a verified petition is something different. And in this context, verified petitions take on some real necessity of integrity. And this was lacking here. But what he did was he said, I added a phrase in there, well, it's expected that this putative father or mother will violate, will do these things. If the light has gone on and you now understand you've made a mistake, you don't ever believe you can get your clients to verify that expectation. And that happened after the fact.
And it would be ludicrous for me to disagree with you on that. I do agree with you, and he has changed. Now he's not doing it anymore. He does the research that's necessary. He does the factual research that's necessary. Then he prepares his pleadings and makes sure everything in that pleading is accurate. That's what he has learned during the course of this process. And that's why I think the slap of 6 months, which we talk about like 6 months or 18 months, is no big deal. Those of us who have really practiced law in and out over the course of 40 or 50 years know that if you lose your practice for 6 months, you are basically starting all over again after 6 months. And if you lose it for 18 months at his age, it's all over. And I think we just cavalierly look at this some way and say we're going to slap him a little bit. 6 months has his attention. 6 months will hurt his practice. 6 months will make sure that he doesn't do this again. So we are asking the court to follow through, not on what my colleague indicated, the 18 months, but the 6-month sanction, the 6-month indefinite suspension. And she was gracious enough to indicate that they didn't ask for a hearing when he comes back. But if you need that, we're even willing to do that so we can show how far he has come. Without further ado, I believe it's important that Kevin now address this court.
Let me ask you, counsel, because this question, I woke up with this question this morning and I had my clerks do some research on this, but if we were to condition his future adoption practice with some serious probation kind of conditions, or even prevent him from practicing adoption for some period of time, what would be your response to either of those two options?
Interesting. The thunder woke me up. I hear what you're saying. It's interesting. But a probation normally means you have a supervising person who looks at everything that you do. And that's an interesting thing to do. The other thing you can do is what you did in I think it was the Flores case, when he wasn't paying his child support and was behind on child support. You placed him on probation and indicated that if you fall asleep at the switch and don't pay your child support, then you're going to be back here before us and you're going to be suspended. I don't remember what you said. It's a possibility. I hadn't thought about that. I think of probations on people who need to have their practice supervised, not in this type of case. Did I answer your question? I could see you're quizzical about my response.
Well, I mean, let me tell you where I'm coming from. Since I've been on this, well, by the way, since I've been on this court has never considered any suspension of a lawyer to be no big deal. So let's just, stop with that. But
We'll respectfully disagree. I hear you.
when we began triaging the cases that come to this court, and we started triaging, we included criminal defendants who win a new trial at the Court of Appeals. They shouldn't have to wait around for their new trial while the state wants that reviewed. The other areas that we've given expedited treatment to, because of their importance and their significance to people, has been matters of adoption and parental termination and that kind of thing. And that's why the CL case was turned around in 3 weeks. I mean, and the reason these are important, and then the statutes require verified pleadings, and the integrity of this type of practice is, integrity with lawyers in the judicial system is a given, and we rely on it. But boy, we really rely on it when we're starting to talk about terminating parental rights and adoptions and that kind of thing. And so this is an attack on the integrity of a part of the practice that truly requires it. And that's why I'm kind of focused on making sure that your representation to us, that he gets it and he's not going to do it again, that we've got some ability to have that supervised or something. So that's why it came to mind. But this conduct becomes more egregious when you consider the context of it, because it's not just a lawyer made a false representation to the court. Kids are involved and lives are involved much more. And I don't think it's, we can say that this kid's going to bounce back. I mean, this had to have been a traumatic thing for both of these 2-year-old children to get taken out of the only homes they knew because of some lawyer that, made sure that he and his clients were misrepresenting the facts. So the severity of this is pretty high.
Without question. I agree. I agree with all of your remarks. That's true. And when I say, and I don't always come in here and say my client gets it. My client really has to get it. And this man, this lawyer gets it. He got it after your questioning, Judge Johnson's questioning. I think Justice Stagel asked him some questions during that hearing before you. He got it then. And I think you scared the hell out of him. There's no question about it. But it took him a long time, Justice Biles, to reach the point where he could say it and not deny it and hurt himself. Whether you believe that or not, the process did help this man. My client would like to address the court with your permission.
Mr. Kenney?
Thank you. My remarks are in writing, so if I appear to not be looking at the camera all the time, that's why. And I appreciate this opportunity. Although it might not seem like it from the records of this case and the 2 adoption cases that led to it, I am by nature a careful person. I'm not a risk taker. I try to be conscientious and kind and help the less fortunate. I've been in the Big Brothers program for about 30 years. I tutor kids at Operation Breakthrough in Kansas City. I donate to them regularly. I help with a program for the homeless at my church. And I've always tried to carry what I consider these better aspects of my personality into my practice of law. I treat other attorneys like I want to be treated. I show up early for court. I'm respectful of the court and its time. So I'm organized. I try to anticipate questions and prepare for them. But I am very embarrassed to admit that I wasn't prepared for this court's questions at the CL case oral argument in 2018 about the adoption petition I'd prepared. I was honestly caught off guard. As Mr. Ambrosio said in his closing comments to the panel in August of last year, until this court brought it to my attention, it hadn't occurred to me that I violated the rules of professional conduct, and that is truly embarrassing. Because I've always tried to follow these rules. When I have a question, I usually contact Kate Barrett at the Office of the Disciplinary Administrator. Before she joined the office, I contacted other staff attorneys, and I've done this many times over the years, and have always followed the advice I was given. In fact, I contacted Ms. Baird after the CL oral argument asking if I should self-report. And when she said yes, I did. And after doing so, I fully cooperated with the investigator and the Office of Disciplinary Counsel. The pleading errors I made were not intentional. They were inadvertent, but very regrettable. And I understand the seriousness of what has happened. And because of my tendency to take things hard, I have suffered for what it's worth because of what's happened. I've taken antidepressants on and off for a couple of years, and not just because of this case, but because of the related adoption cases as well. I get close to my clients, especially so when the outcome of the case is disruption, as it was in these two cases. But I know that this is not about me, other than how it's changed my practice of law. The experiences have indeed made me a better attorney. As Mr. Ambrosio said, I used to double check, now I triple check. If I'm uncertain about something, I set it aside for a while and come back to it. I work much more slowly and deliberately. I ask lots of questions. I choose my words carefully. I'm a critical editor. I write and rewrite. I still contact Ms. Baird when I have ethics questions. Because I'm a solo practitioner, I have developed a network of attorneys that I consult with when I'm unsure about something, and I rely on them now more than ever. If I'm uncertain about what I should allege in a pleading, I seek advice. I share motions, briefs, proposed orders, etc. with them, asking for feedback, and I'm always open to suggestions for changes. The experiences of this action and the related adoption cases have taught me to check and recheck my documents, my case strategy, and my understanding of the law for inadvertent errors and/or a better approach. In closing, I want the court to know that I have reflected deeply about this action and the two adoption cases since I self-reported in November of 2018. I can assure you that I've been changed as a person, and most importantly, as an attorney, for the better. And I appreciate this opportunity to address the court.
Counsel, or I'm sorry, Mr. Kenney, when you were preparing the petitions for adoption and termination of parental rights, you were listing the statutory factors that would justify either individually or collectively termination of the other parent's parental rights. And based on the findings and conclusions, at the time you did that, sometimes you didn't know whether there were facts to back those reasons up or those statutory factors up. I'm interested to know, just at the time, what was going through your mind as you were preparing those petitions and getting them filed.
Thank you, Your Honor. My approach, and in hindsight, was wrong, was kind of a kitchen sink approach, include all of the statutory factors in the original petition. And I know that was not the way to do it then, and I certainly have not done it since then and would not ever do it again in the future.
Were you aware that it required a good faith basis to make assertions like that at the time?
Yes. But it wasn't an intentional disregard of that obligation, Your Honor. I didn't think of it. And that's the honest truth.
And I think the problem with that explanation is what was going through your mind when you had your clients verify that these allegations were true?
I understand your concern, Your Honor. I should not have done that, and I regret that I did.
Any other questions for Mr. Kenney? Ms. Boykins?
Thank you. I have to respectfully disagree with Mr. Ambrosio that a 6-month suspension would be adequate in this case. I think that the severity of the harm caused and the serious misconduct in this case warrants a longer suspension, and I believe 18 months is appropriate for the reasons I've already stated. I'm not sure what impact this has on the consideration, but the respondent does continue to have a Missouri license and is good standing in Missouri, as far as our office is aware. So I think 6 months, it is not enough. Also, Justice Biles's mention of a probation sparked my thought that if this court were to put into place a probation at the end of a suspension, it would be good to have a practice supervisor put into place to review Mr. Kenney's pleadings prior to filing to make sure that nothing like this ever happens again. I think that would help to protect the public here. If there are no further questions, that concludes my rebuttal.
Any questions? Doesn't appear as if there are. So thank you to everyone for your arguments today and statements. We will take this matter under advisement. The court is now in recess until 9 a.m. tomorrow morning.